Let's go to Derek calling.
Good morning. My question is, I was just recently put onto the deed of a property that my father owned, and he lived up in New Hampshire, and the property was here in Florida. He just recently passed away, and I'm trying to figure out, is the property automatically transferred to me, or do I have to record an affidavit of survivorship or anything like that?
All right, well, it depends on the magic words on the deed, I call it. So if the deed was dad's name, your name, and the magic words jointly with right of survivorship on the deed?
Yes.
Upon his death, they would... Upon his death, it automatically goes to you. Just file a death certificate at the courthouse.
File the death certificate at the courthouse?
Yeah, because that's where the deed's recorded. So if the deed, the deed did not have the magic words with jointly with right of survivorship on the deed, then that would be considered tenants in common, and that would have meant that you own half, your dad owned half individually, and his half would have to go through probate. If the deed, if the magic words behind the names are tenants in common, then his half would have to go through probate. If there are no magic words, that's tenants in common, it would have to go through probate. If it's jointly with right of survivorship behind the names, then it automatically goes to you, and all you have to do is file a death certificate at the courthouse.
Just file the death certificate at the courthouse, and there was a mortgage on the property. Do I have to inform the bank that he's deceased or anything?
Well, do you have to? No. Can you keep making payments? Probably yes. A lot of people will tell the bank that he died, and they'll assume the mortgage. And the bank will usually just let you assume it. But people do all kind of various things on that. Some people just continue making the payments because they're concerned the bank won't let them continue the mortgage. Both names. Let me ask you this: if you bought it in both names, did you both assume that? Did you both sign for the mortgage?
No, we did not buy it in both names. Only he bought it.
And then you transferred it to you.
He was the only one on the mortgage.
Okay.
I'm sorry.
So he bought it, and then when did your name get on the deed?
Literally a couple weeks before he passed away.
I see. That's not totally good. If he had died and left it to you, you would get a stepped up. How long had he owned the property?
He'd only owned it about a year.
Okay, well, that's probably okay then.
Yeah,
the cost basis won't be affected. Technically, he should have, his estate technically should do a gift tax return because the value of what he gave you is more than $15,000. And there wouldn't be a tax due, but there was a gift tax form due because of the amount of the value of the gift. But he could elect not to pay a tax and use up part of his lifetime exemption. So unless he had more than $11.5 million, it wouldn't be an issue really of any payment.
Okay. So as far as just taking the death certificate down to the courthouse and recording that, the property will then transfer into my name. But if I can just keep making the mortgage payments without it. I didn't know if the bank was going to basically try to accelerate the loan or something and demand the entire amount of the note immediately or something.
Well, that's the other thing. See, since there was a mortgage on the property just in his name and him being the owner, the bank would have the right to accelerate because he made a gift of the property while he was living to you and added your name. And technically, the mortgage probably states that if that happened, the bank could probably accelerate the loan. So whether they will or not, because now he's died and it was going to be yours anyway through the estate, they may or may not accelerate the loan. Is it a favorable interest rate to them or to you?
I guess to them, it's like 5%.
Well, you might want to seek new financing and get a loan for 3 or 4%.
Right.
And then that wouldn't be an issue.
I was even thinking if I went to sell the property,
mm-hmm.
Could I just do I sell it without any impediments there? Am I legally able to sign like a listing agreement with a broker and sell it?
Yeah, you're the owner now, so sure. Then the mortgage should just be paid off at the time of the sale from the proceeds.
Okay. All right. I guess that's what I'm going to do.
All right.
now.
Well, if you need any other help with any questions you have, feel free to call me. I don't charge for questions. I don't charge people on the radio, so how can I charge people in my practice? This is kind of the way I think about it. So, all right.
That's great. Thank you, Joe.
All right. Thank you.